Hello friends, in today's class we will learn about Supreme Court. According to Krishnaswamy Iyer, the Supreme Court of India has more powers than any other Supreme Court in any part of the world. The judiciary is an important organ of the government that performs the role of independent dispute resolution. Indian judiciary is one of the most powerful judiciaries in the world, and it has been the nation's moral conscience, speaking truth to political power, upholding the rights of citizens, mediating center-state conflicts, providing justice to the rich and poor alike, and several momentous occasions, saving democracy itself. India is a federal state with a single and unified judicial system with three-tier structure. Supreme Court at the top, High Courts at state levels, and subordinate courts at the district levels. Historical background and evolution. Regulating Act of 1773 established the Supreme Court of Judicature at Fort Williams, Calicut as a court of record with full power and authority. This was the highest court of British India till 1862. Before the establishment of High Court Calcutta through the Indian High Court Act. Government of India Act 1935 established Federal Court of India with jurisdiction to solve disputes between provinces and federal states and hear and appeal against the judgments from high courts. Integrated judicial system adopted from Government of India's Act of 1935. Post-independence, the Supreme Court of India came into existence on 26th January 1950. The first sitting was held on 28th January 1950. According to Article 124(1) of Indian Constitution, there shall be a Supreme Court of India constituting a CGI until Parliament prescribes a larger number, not more than 7 other judges. The Supreme Court is a guarantor of fundamental rights of the people and guardian of the Constitution. Parliament is authorized to regulate the organization, independence, jurisdiction, powers and the procedures of the Supreme Court. Position of Supreme Court under the Constitution. Federal and highest constitutional court of India with the power of judicial review. Highest court of appeal. Final interpreter of the Constitution. Protector and defender of fundamental rights. Court of record under Article 129 of Indian Constitution. Procedures of the Supreme Court. With the approval of the President, the Supreme Court can make rules for regulating generally the practice and the procedures of the court. Constitutional cases or references made by the President under Article 143 are decided by a bench consisting of at least 5 judges. All other cases are generally decided by a bench consisting of not less than 3 judges. The judgments are delivered by the open court. All judgments are pronounced by majority vote. Appointment of judges. The Chief Justice of India is appointed by the President after consultation with such judges of the Supreme Court and High Court as he or she deems necessary. The other judges are appointed by the President after consultation with the CGI and such other judges of the Supreme Court and the High Court as he or she deems necessary. Consultation with the Chief Justice is obligatory for appointing a judge other than the Chief Justice of India. Qualification of judges. He or she should be a citizen of India. He or she should have been a judge of High Court for 5 years, or he or she should have been an advocate of High Court for 10 years, or he or she should be a distinguished jurist in the opinion of the President. No such provision for the judge of the High Court. Constitution has not prescribed the minimum age for the appointment as a judge of the Supreme Court. Oath or affirmation. A person appointed as a judge of the Supreme Court before entering upon his or her office has to make a subscribe to an oath or affirmation before the President or some other person appointed by him for the purpose. Tenure of judges. The Constitution had not fixed the tenure of judges of the Supreme Court. He or she holds the office until he or she attains the age of 65 years. Any question regarding his or her age is to be determined by such authority and in such a manner as provided by the Parliament. He can resign by writing to the President. Removal of judges. A judge of the Supreme Court can be removed from his or her office by an order of the President on the recommendation of the Parliament. The address must be supported by a special majority of each House of Parliament, a majority of the total membership of that House, and a majority of not less than 2/3 of the members of that House presented and voting. Grounds for removal. Proved misbehavior or incapacity only. Judges Inquiry Act 1968. The Act governs the process for impeachment of the Supreme Court judges. No judge of the Supreme Court has been impeached so far. Justice Deepak Mishra from 2017 and 18 and Ramaswamy 1991 to 1992 both had their impeachment motions, but the same were rejected by the Parliament. Salaries and allowances. Salaries and allowances are determined from time to time by the parliament. They cannot be varied to their disadvantage after their appointment except during a financial emergency. For more such videos, please subscribe our channel.